Hello, everyone, and welcome. In light of recent escalations, including Israel's decision to sever relations with the United Nations Relief and Works Agency, UNRWA, and the ongoing pressure campaigns against the International Criminal Court, I would like to welcome everyone to the Arab Organization for Human Rights in the UK webinar, Justice and Humanity Under Threat. Israeli campaigns targeting the ICC and UNRWA. We have brought together prominent legal experts, human rights advocates, and international lawyers to examine the threats and interference facing the ICC and UNRWA, particularly in regard to the Palestinian issue, the role of Western governments in supporting Israeli actions and undermine international accountability and humanitarian efforts, the increasing challenges to humanitarian aid channels like UNRWA, strategies and urgent steps needed to uphold justice and ensure the protection of aid efforts for the vulnerable communities, and the recent complaint before the Dutch judiciary concerning Mossad's threats against ICC officials. And finally, to highlight the broader implications of these pressures on justice and humanitarian relief. We would like to welcome members of the public, human rights advocates, and media professionals to join and contribute to this essential conversation. We have several distinguished speakers, including Professor Michael Link, former UN Special Rapporteur to the occupied Palestinian territories, Haroon Raza, Dutch lawyer and member of 30 March movement, Dr. Lex Teckenberg, senior advisor to ARDD and former director of UNRWA operations, Professor Steven Zunes, professor in international security and foreign policy at the University of San Francisco. Also Emilio David, Palestinian Chilean lawyer and professor of law. And finally, Sarah Flounders, co-director of the International Action Center. Thank you all very much. Now I would like to introduce as our first speaker, Professor Michael Link, foreign UN Special Rapporteur on the occupied Palestinian territories. Thank you, Professor Link. I would like to remind you that we have about 5 to 7 minutes for each speaker.
Thank you very much for inviting me today. It's a pleasure to be here, and it's a pleasure to be on such a distinguished panel. What I'd like to address is are two issues. First and foremost, the question of what should be the status of Israel with respect to the United Nations in the aftermath of what has been happening recently. I note as a short page of indictment that we had the Prime Minister of Israel in late September speaking at the General Assembly, calling it a house of darkness, among other things, as well as had the stench of anti-Semitism in it. We've had the legislation passed recently in the Knesset, which would, within the next 3 months, ban the operations of UNRWA in East Jerusalem, the West Bank, and Gaza. We've had, during the course of the war on Gaza and over the last almost 400 days, we've had over 100 attacks on UN schools. We've had over 230 UN workers killed during the course of the military campaign in Gaza, which is by far the highest number of UN workers ever killed in a single conflict. We've had the foreign minister of Israel declare that the Secretary General of the United Nations is a persona non grata in Israel. We've had the decision by the International Court of Justice released in July, which Israel immediately said it was not going to put into effect. We had this decision, this advisory opinion of the International Court, passed overwhelmingly, welcomed overwhelmingly by the UN General Assembly in September, which was followed then by denunciation by the Israeli ambassador as diplomatic terrorism. So the question then becomes, with what many experts agree is a genocide occurring in Gaza, with what many human rights voices have said is the application of genocide, of apartheid in the occupied Palestinian territories, if not in the entirety of the land controlled by Israel between the Mediterranean and the Jordan River, all to be apartheid. We also have over 30 resolutions of the Security Council that Israel has defied over the last 45 years. These resolutions are on the illegality of Israel's annexation of East Jerusalem, on Israel's refusal to accept and apply the Fourth Geneva Convention to the territories it has occupied since 1967. These apply to the illegality of the Israeli settlements, as well as resolutions with respect to Israel not taking effective action to end the violence of the Israeli settlers and ensure the protection of Palestinian civilians in the occupied Palestinian territory. And finally, a series of resolutions by the Security Council, which have proclaimed the principle of the inadmissibility of the acquisition of territory by war or by force, all of which are in breach of Israel by Israel. So then the question becomes, should Israel's membership in the United Nations be reviewed and possibly revoked? We have one precedent from 50 years ago where South Africa was unseated by decision of the General Assembly. And let me just say that when you look at the Charter of the United Nations, it says in Article 25 that all members must obey all decisions of the United Nations Security Council. And all of the 30-some resolutions that I have cited in these 5 categories would be considered to be decisions of the Security Council. There then is Article 6 of the Charter, which says that the Security Council can take actions to suspend or remove the membership of a member of the United Nations, which is not acting in compliance with the values and the principles of the Charter of the United Nations. This is what happened with respect to South Africa in the late 1960s and early 1970s, reaching a crescendo in 1974. A resolution was introduced at the Security Council under Article 6. 3 members of the Security Council, permanent members, vetoed the resolution: France, the United Kingdom, and the United States. This then went to the General Assembly, which, acting, in fact, almost inventing a new procedure on its own, voted to not accept the credentials of South Africa, and apartheid South Africa then remained outside of the United Nations. It was effectively unseated until the elections in 1994, which ushered the end of apartheid South Africa and the beginning of a democratic South Africa. Should these same matters be dealt with respect to Israel? I think Israel's given the United Nations a large number of reasons as to why its membership should be reconsidered. I do understand, albeit from afar as a Canadian, that there are a number of pieces of legislation within the American Congress that would likely be triggered if actions like this were taken against South Africa. But we're bound to face a crisis one way or the other within the next year between the United Nations, Israel, and likely then involving the United States. The resolution passed by the General Assembly in September, welcoming the advisory opinion of the International Court of Justice, gave Israel 12 months, beginning on September 18th, 12 months to vacate and end the occupation entirely, to remove and evacuate all of its 730,000 or so settlers from East Jerusalem and the West Bank, and to be able to recognize a Palestinian state. It's highly unlikely that Israel will comply with this. Therefore, when the diplomatic alarm clock rings next September, I think the international community and the United Nations will face a significant crisis, perhaps one of the most important crises in the history of the United Nations, as to how to handle the question of Israel, and as well how to manage its relationships with the United States, whoever is in power in the aftermath of tomorrow's elections. And if I can just briefly comment on the issue with respect to the question of the judge on the pretrial chamber of the International Criminal Court, who's just been appointed to replace one of the alien judges who's removed himself from the three-person panel deciding the question of whether or not to accept the application for arrest warrants issued by the or made by the prosecutor of the International Criminal Court back in May. The question has arisen as to whether or not what are the leanings of this particular judge. Comments have been made that the judge had made 9 years ago with respect to the fact that there is the issue of complementarity with respect to any arrest warrants which ought to be issued with respect to individuals, and whether or not the domestic judicial system and justice system of that particular country can actually handle fairly and reasonably the request to review the international criminal charges laid against that person or persons. My own reading of this is that this judge's comments were made 9 years ago, that today there is in front of the court a detailed written application, which I think is a masterpiece of legal advocacy. And part of that is I think a fairly comprehensive answer to the failures of complementarity within the Israeli judicial system, that none of the allegations made against Prime Minister Benjamin Netanyahu or Defense Minister Yoav Gallant are with respect to war crimes of starvation and other sort of war crimes and crimes against humanity contained in the particulars, have been investigated by any serious body within the Israeli legal or justice system, and that the issue of complementarity really doesn't arise in the minds of any reasonable interpreter who would look upon this dispassionately. And I think I would hope, and I guess my leanings would be, is that this judge is certainly capable of giving an unbiased, judicious review of these applications, notwithstanding what her remarks were 9 years ago. Thank you very much.
Thank you so much, Professor Link, for your very informative words and sharing your expertise. We would like to move on to Harun Raza, if you could please share.
Certainly. Thanks so much for having me. And just a very small correction. I'm not a member of the March 30th movement, although I support them wholeheartedly. I'm their lawyer. And I'm also the lawyer of the Hind Rajab Foundation, which is linked to the March 30th movement.
Thank you very much.
No problem whatsoever. I'd like to say something about the ongoing complaint, which was lodged before the Dutch Public Prosecutor's Office regarding threats against the ICC. As we all know, the ICC has been under extreme scrutiny regarding the investigation in connection with war crimes, crimes against humanity and genocide, which are being committed in Palestine, as we are seeing on a day-to-day basis. And in that regards, we also know, and I think it started with the Guardian report from the Guardian newspaper, that one of the judges at the ICC was being threatened and caused during, I think, about 9 years, a period of 9 years. And if I'm not mistaken, that was, at least that's what the Guardian reported, that was at the behest of the former chief of the Mossad. And what's happened in this country is there have been parliamentary questions raised about the role of the Dutch police and the Dutch prosecution service in safeguarding the ICC's work, because as we all know, it is based in The Hague. And a law firm based in Amsterdam, who are specialized in international humanitarian law, have in fact lodged a complaint, I believe it was on the 8th of October of this year, against not just Israeli security officials based in this country. And I believe that it's pointed towards security officials who have something to do with the embassy, the Israeli embassy in The Hague, but also US senators. As we all probably know, as you all well know, a group of US senators sent a letter to the ICC threatening the ICC that if any action was taken against Israeli war crimes regarding Palestine by the ICC, they would take further action by the US Senate. Those senators, as far as I've understood, those senators have been named in the complaint, and the complaint is regarding those senators using or misusing their authority in threatening and coercing the ICC. And the other part of the complaint is geared towards the Israeli officials who have clearly, physically coerced and threatened the ICC and or ICC officials. Again, it's a fresh complaint. It was lodged about a month ago. We have no official information regarding the stages of that investigation. What we do know is the previous Minister of Justice did comment on any and all actions by the Dutch government regarding Israel in regards to the threats and coercion towards ICC. And all the previous government said was, because of security issues, we can't give you, Parliament, any information regarding ongoing investigations into Israeli coercion or threats towards ICC. So to sum it up, yes, there is an investigation going on, at least one. We do not know the exact stages of the investigation, but I do think that looking at the evidence which we have been presented with by The Guardian, by other outlets, there's a clear case for finding at least reasonable suspicion of criminal acts, and a clear case for the Dutch prosecutor's office to open and conduct a proper investigation, and also perhaps a prosecution of the individuals involved, including US senators. So that's something which we will be seeing, I think, in the coming months, but we shouldn't hold our breath regarding when there will be a decision by the Dutch prosecutor's office, because it does take some time. So that's why I wanted to share regarding that complaint and the investigation in general. We have many other topics which I received by mail, which we will discuss today. Is there anything other? Are there any other topics specifically which you would like me to comment on, or can we move on to another speaker, I guess?
I think we can go ahead and move on to another speaker and perhaps come back.
Certainly.
That's all right. Wonderful. Thank you. I would like to welcome Dr. Lex Teckenberg, Senior Advisor at ARDD and former Director of UNRWA Operations. Welcome, Professor Zunes.
Thank you very much for inviting me to this great panel and important event at a critical time. Can you hear me okay? I had some internet problems a little while ago, but I hope I'm clear. Let me know if not. I would like to comment in my initial introductory opening on the latest ban against UNRWA by the Israeli Knesset, Israel's parliament, exactly a week ago, in the form of two laws that have been adopted. One sort of essentially telling UNRWA to close down its activities in areas under Israeli sovereignty, which includes, for Israeli perspectives, East Jerusalem, and a second law essentially instructing Israeli officials to have no dealings with UNRWA whatsoever. This latter bill would also sort of involve the withdrawal of the rescission of the agreement between Israel and UNRWA adopted at the very time of the 6-Day War in 1967, when Israel requested UNRWA to continue its operations in Gaza and the West Bank, including East Jerusalem. So these two laws have been adopted, subject to a sort of an implementation timetable of 90 days. That's when they will take full effect. In the meantime, the Israeli Ministry of Foreign Affairs has already notified the UN Secretary General that it will revoke its consent to this agreement between UNRWA and Israel. These latest legislative measures are the culmination of attacks against UNRWA that essentially have been going on almost since 1967 and gradually got more severe and serious and reached an existential sort of stage since the onset of the current Israeli government, and in particular since the start of the war in Gaza 13 months ago. How it will all play out is not entirely clear. The laws will, the primary aim seems, or the one key prize that UNRWA that Israel hopes to get is the UNRWA headquarters in East Jerusalem, that is located in primary sort of real estate and surrounded by Orthodox housing. So that is one particular thing Israel is aiming at. But much more widely, it is aiming to close UNRWA's operations in both the Gaza Strip and the West Bank. These measures have created a sort of an unprecedented legal dilemma and legal crisis for the UN. They violate 3 orders by the International Court of Justice in the genocide case to step up rather than hinder the delivery of humanitarian aid. They also violate the advisory opinion of the International Court of Justice in July on declaring the entire occupation of Gaza, the West Bank, including East Jerusalem, illegal, and then subsequently the General Assembly instructing Israel to vacate the occupied territory, and also instructing third state as well as international organizations, including the UN, to sort of not cooperate with Israel in further consolidating its control over the occupied territories. And this legislative measure is sort of a clear violation of that. Rather than sort of leaving the West Bank and Gaza itself, it wants UNRWA to leave and to aggravate the situation for the Palestinian refugees. As I mentioned, the exact implications of how these laws will be implemented, how this ban will be fully extended and implemented will become clear in the coming weeks and months. I personally think that Israel is not likely to sort of rescind them as a lot of Western governments are imploring Israel to do. The rate of implementation, or the level of implementation may vary depending on the specific geographic locations. Now the implications for Palestinian refugees, if fully implemented, will be enormous. UNRWA is in Gaza, even though it has come under enormous attack. It remains the lifeline for Palestinian refugees, and is also a vehicle through which many other UN agencies and non-governmental humanitarian agencies sort of are able to deliver their assistance. They use UNRWA's logistical capacity, its manpower, its installations, to work together as a humanitarian system to provide, relief under the most difficult circumstances. So if UNRWA is further prevented by Israel from playing that role, the crisis will only dramatically, exacerbate and deteriorate. In the West Bank, so far, UNRWA's schools and health centers operate. If Israel is going to prevent that from happening, this will be another bombshell, quite likely to trigger new violence, which in turn may give Israel an excuse to further extend its genocidal actions in the Gaza Strip, also to the West Bank, as the current special rapporteur in her latest report, Francesca Albanese, has warned. There is already, there's a significant risk of spillover of what is happening in Gaza to the West Bank. So a very dramatic situation. My understanding is that on Wednesday, the General Assembly is convening an emergency session to consider the legislation. There is also a Security Council resolution circulating, once again calling for a ceasefire, but in much stronger language than in previous redemptions. That also makes reference to the UNRWA legislation. Norway has indicated it may make a referral to the International Court of Justice to seek suggest to the General Assembly a further advisory opinion from the International Court of Justice to sort of clarify Israel's humanitarian obligations. So there's a range of measures. There's also the possibility of Malaysia has been taking an initiative in that respect to sort of suspend or to withdraw Israel's credentials from the General Assembly, effectively, placing it really as a formal outcast in the framework of the United Nations. So there's a lot under consideration in this respect. It is indeed an unprecedented situation, and I'm happy to answer further questions about it, in response to questions from the audience. So thank you very much for the opportunity.
Thank you, Dr. Tecklenburg, thank you for that information. And if any of the guests would like to have some questions, please do post those. Right now, I'd like to go back and speak again with Harun Raza. We have a question here. As a lawyer who's already filed a complaint against over 1,000 Israeli soldiers before the ICC, how do you view the recent harassment accusations against Karim Khan? And regardless of their credibility, how do you interpret the timing of these accusations? And do they suggest potential blackmail or a threat to the court's independence?
I think there isn't much doubt about the timing of these so-called accusations. And of course, I'm not privy to what the accusations exactly were. However, on my phone, I've just looked up on X what Mr. Khan said about this. And he has a tweet or X post on the 20th of October addressing this, in which it seems as though in May of this year, certain third parties did allege certain things being happened, that that was in fact reported to the proper authorities, and that that person or persons or those persons then subsequently declined to further the complaint. So it seems as if this issue has already been dealt with. And if we look at the first subject we were discussing regarding the threats and coercion and the intimidation of the ICC by US senators, by Israeli officials, by the former head of the Mossad, this seems to be a pattern in which either ICC officials or officials from the Office of the Prosecutor are being harassed in a structural way. And I don't think we need to be a rocket scientist to think of the reason why. It's very simple. Israel and Israeli soldiers and Israeli officials are feeling the heat of international justice, the war crimes against humanity, and the genocide, again, in my view, is very clear. And I think they do understand that they will be held to account for the various crimes which they have committed. So I don't think there's any other way to frame this except for this being a witch hunt, not to use terms which might be used tomorrow after the US elections, but that's above my pay grade. Having said that, I really do think that this is what's happening. And I think we all just have to keep our eye on the ball, which is being sure that the ICC is working in an effective way, in an effective fashion in going after war criminals and making sure they can do their job safely.
Thank you for that. Next, I would like to move on and welcome Professor Steven Zunes. He's a professor of international security and foreign policy at the University of San Francisco. Hello, Dr. Zunes. Oh, I'm sorry, can you unmute?
Hello, and thank you for including me in this important discussion. I want to start off by noting how the United States government has been actively working to block the indictments of Netanyahu and Gallant by the ICC. What exactly they're doing is not public, but I would like to review the initial reaction in Washington to the report by the prestigious team of international jurists and legal scholars this past spring recommending the indictments. And the angry reactions from Biden's administration and congressional leaders are not simply another defense of Israeli war crimes, but an attack on international humanitarian law itself. I mean, Biden denounced the report as outrageous, making the first time in U.S. history that a sitting president has openly sided with the suspected war criminals against the ICC. And despite nothing in the report questioning Israel's right to self-defense, Biden insisted on pledging, "We will always stand with Israel against threats to its security." Now, it's odd that Biden would denounce this incredibly prestigious body of lawyers and barristers. I mean, Joe Biden finished in the bottom 10th of his law school class at Syracuse University. I mean, he is no legal scholar, to put it mildly, but yet he believes he somehow knows more about this prestigious panel, which has, worked on all sorts of different international humanitarian law questions. Secretary of State Antony Blinken, called the report shameful, a profoundly wrong-headed decision, which the United States, fundamentally rejects. And we know the ICC prosecutor, Karim Khan, in accepting the British-based panel's unanimous recommendations, noted how the report indicated that he had reasonable grounds to believe that Netanyahu and Gallant, along with the 3 Hamas leaders who've since been assassinated, who were also recommended for indictment, do bear criminal responsibility for alleged war crimes and crimes against humanity. Ironically, Khan, a British lawyer, was considered to be Israel's preferred candidate for the position of ICC prosecutor, since he was seen as less likely to prosecute Israeli officials than his predecessor, the Gambian lawyer Fatou Bensouda. Amal Clooney was one of the prominent lawyers. She's represented other victims of mass atrocities, and ironically had been criticized previously for not speaking out against Israeli war crimes. But she supported the panel's decision, so noting that regardless of the reasons for a conflict, as a human rights lawyer, quote, I will never accept that one child's life has less value than another's. I do not accept that any conflict should be beyond the reach of the law, nor that any perpetrator should be above the law. Amnesty International praised the decision. Human Rights Watch praised the decision. And there were some people in Congress, Bernie Sanders, a senator who is one of the most prominent Jewish lawmakers in the United States, defended the court's recommendation, saying the ICC prosecutor is right to take these actions and that it is imperative that the global community uphold international law. Yet there is the vast majority of members of Congress who spoke out on the issue. Both Republicans and Democrats attacked the ICC. It was clear they hadn't even read it because they misrepresented it, and so the recommendation in so many ways. I mean, saying that they keep singling out Israel, and Israel, of course, is the first indictment against any Israeli officials. Until last year, all 53 indictments had been against African officials, and subsequently you have a number of Russian officials. But this is the first time an allied government had been of the United States had leaders attacked by the ICC, and suddenly there is this anger that basically what Washington is saying is that the International Criminal Court should only be used by people we don't like, we don't support, and it cannot be used. I mean, this is the double standard in international law. It's obvious to anybody. Now, a key argument the Biden administration and congressional leaders put forth against the likely indictments is that the ICC doesn't have jurisdiction to indict Israeli leaders because Israel isn't a party to the Rome Statute, which is the 1998 treaty which established the ICC. However, the state of Palestine acceded to the Rome Statute in 2015, giving the ICC authority to prosecute parties who commit crimes on or from Palestinian territory. Clooney, noted, referencing the panel in her statement, underscored the fact that, quote, we have unanimously determined that the court has jurisdiction over crimes committed in Palestine and by Palestinian nationals. Although neither Russia nor Ukraine are parties to the Rome Statute, there is no U.S. opposition to the ICC's indictment of Putin and other Russian officials for war crimes related to the Russian invasion of Ukraine. Again, we see this double standard. I mean, the administration has long been opposed to any examination into Israel by the ICC. Back in 2021, when the court first launched an investigation into war crimes committed in Palestinian territories, the State Department rejected the announcement. Despite the state of Palestine being recognized by over 140 countries, the State Department said in a briefing that, quote, the Palestinians do not qualify as a sovereign state. The Associated Press reporter Matt Lee asked Ned Price, the State Department spokesman, no less than 12 times where the Biden administration believed the Palestinians should seek accountability, but he refused to offer any alternative to the ICC. And the current State Department spokesperson, Matthew Miller, also insisted the ICC had no jurisdiction regarding war crimes. And when he was asked by a reporter, the same reporter actually, who would have jurisdiction through which the Palestinians could seek justice for war crimes committed against them, he replied with a novel statement that the government of Israel has jurisdiction. And we have jurisdiction with the use of our military aid that we have provided. But of course, the U.S. position is all this military aid should be unconditional. I mean, the claim that Israel can hold its leaders and soldiers accountable has little bearing on reality, as has been repeatedly documented by human rights organizations like Amnesty International and Human Rights Watch, and the Israeli human rights groups like B'Tselem that have documented how Israeli policy, quote, effectively grants immunity to soldiers and officers, with the result that soldiers who kill Palestinians not taking part in hostilities are almost never held accountable for their actions. And that's why B'Tselem cheered the decision by the ICC panel, saying the era of immunity for Israeli decision makers is over, adding the international community is signaling to Israel that it can no longer maintain its policy of violence, killing, and destruction without accountability. Now, a recurring theme from Washington is that the requests put forth some kind of equivalence between Israel and Hamas. Biden himself said, whatever this prosecutor might imply, there is no equivalence, none between Israel and Hamas. In reality, however, the panel's report charged Israeli and Hamas officials with separate crimes, citing specific and distinct wrongful conduct by both. For example, Hamas leaders were charged with more crimes against humanity, the more serious of the charges, while Netanyahu and Gallant were more frequently charged with more lesser war crimes. Indeed, as some critics have pointed out, the panel's findings overlook the more systemic war crimes committed by Israeli officials. But despite this, there is, the U.S. has insisted that the bias is somehow the other way. Now, the response to these proposed indictments should not be simply seen as another knee-jerk pro-Israel reaction so commonplace in Washington. The U.S. government has long opposed the very existence of the ICC. A bill passed with bipartisan support in 2001 and signed by President George W. Bush prohibits the United States from cooperating in any way with ICC investigations, calls for punishing countries that do, and even authorizes the president to, quote, use all necessary and appropriate measures, including military force, to secure the release of American or allied personnel held by or on behalf of the court. This was nicknamed the Hague Invasion Act. And the reaction to the likely indictments of Netanyahu and Gallant, therefore, should not be seen in isolation. Indeed, past U.S. governments' support for genocidal military campaigns by allies like Indonesia and East Timor, Turkey in the Kurdish regions, Pakistan and Bangladesh, Guatemala in the highlands, and more recently Saudi Arabia and Yemen, is indicative of the long-standing contempt for international humanitarian law among Washington officials. As long as the current administration and congressional leadership are in power, future war criminals from allied states will know that they can slaughter people with impunity, and the United States will have their backs.
Thank you so much for sharing that expertise. We will, let's see. I would like to go, we had a question come up. I'd like to go back to Professor Link, our former UN Special Rapporteur on the occupied Palestinian territories. We had a question come through. Earlier this week, UN Special Rapporteur Francesca Albanese stated that the UN should consider suspending Israel over genocide. What steps would member countries need to take to pursue this suspension? Additionally, do you believe this could ever be realized, or will the US veto continue to be a major barrier? Could you speak to that, please?
Sure. I'll repeat what I'd said in my opening statement. The decision to be able to suspend the membership of a errant member of the United Nations rests in Article 6, and that states that a member state that has persistently violated the principles contained in the present charter may be expelled by the General Assembly upon the recommendation of the Security Council. Now, it would appear obvious that as long as the United States is a permanent member with a veto, the United States would never permit a resolution to go through the Security Council recommending to the General Assembly that a member be expelled, i.e. Israel. However, precedent from 50 years ago, in October, November 1974, shows that there's an alternative path in a new procedure that was created by the General Assembly in dealing with an errant member, in that case, apartheid South Africa. The month before, the Security Council had debated a resolution to expel apartheid South Africa under Article 6. 3 members of the Security Council, Britain, France, and the United States, vetoed the resolution. The matter then was taken up by the General Assembly, who passed, which is a much more democratic institution with no veto powers by any member, and it created, if you like, a new precedent by voting to not accept the credentials of apartheid South Africa, effectively unseating it, and it stayed outside of the United Nations for the next 20 years until after the 1994 elections, which ushered in the new democratic phase of South Africa. That would be the procedures at the United Nations in order to be able to address the question of whether Israel should maintain its UN membership. I should point out, as I pointed out earlier, that I know that while not being intimately familiar with it, I know that there is legislation adopted by the United States through its Congress, which would likely trigger the banning of any financial support going to the United Nations by the United States, should any action be taken by the United Nations, either to recognize Palestine as a full member or to take some adverse action against Israel. The United States has or offers somewhere between 1/4 and 1/3 of the financing for the annual budget of the United Nations. So this, has all the makings over the next year of being a crisis in the making. I know Malaysia mentioned earlier on today that it supported the expulsion of Israel from the United Nations. Whether or not there's enough support this year, I'm not sure. I certainly haven't seen it yet. But come next September, when the 1-year deadline set by the General Assembly for Israel to entirely vacate its occupation and bring all of its troops and all of its settlers back behind the June 4th, 1967 lines becomes in effect. We will then see, I think, a showdown between the General Assembly and Israel, and likely then the United States, as to where we go.
Thank you so much for addressing that question. I'd like to move on now and welcome Dr. Emilio Dabed. He's a Palestinian, Chilean lawyer and professor of law. Welcome, Dr. Dabed.
Hello, thank you. Thank you so much for having me. I wanted to highlight something that has been concerning me for a long time, is the fact that, we are here denouncing certain double standards from the US, Western Europe, and Europe more generally, regarding the application of international law and the use of international courts. And at the risk of sounding like a broken record, because part of what I want to say, I think I had said it in this same forum some time ago, is that we are trying to solve a problem of double standard in the application of international law by resorting to courts. And without considering that everything shows that these international courts are also in a certain way part of the problem. If we assume that we see these Western powers using the international legal system rather than for eradicating violence at the global level, rather than eradicating violence using the international legal system in order to administer their violence, right? I cannot draw any other conclusion than saying that courts, international courts, and the ICJ and the ICC are participating in this exercise of administration of violence. So they are participating in what you call the double standard. And so it's a paradox, right? We are trying to fix the double standard by resorting to institutions that are also applying it. And in my last intervention here, I think I referred to some of the critiques that one can do, one can make, for example, of the ICJ decision about the genocide in the genocide case of South Africa against Israel on the 26th of January 2024 by saying it's paradoxical, right, that the court says that a genocide is plausible, is plausible there, but they would order indicate provisional measures, but they would not indicate the only provisional measure that had actually the potential, at least, of stopping the genocide, which was a ceasefire. And many people said, so the court is saying, look, we have evidence that makes us think that there are grounds to think that a genocide is happening there, and the situation is so serious that we will indicate provisional measures, but they will not indicate the only provisional measure that had the potential of stopping the genocide, which is a ceasefire. Some people said, no, look, it's just that ceasefires cannot be unilateral, they need to be bilateral or multilateral. You cannot order only one party to cease fire. I assume that there are some reasons to believe that, right? And in terms of protecting the right of states to defend themselves, right? But that operates only in the case a state is defending itself according to international law. So this explanation that the court did not order a ceasefire, did not order to Israel to cease fire in Gaza was because ceasefires cannot be unilateral is not true. It doesn't have any grounds on law or in previous decisions of the ICJ. Article 41 of the Statute of the ICJ gives to the ICJ all the possibility of indicating all measures that the court considers necessary. And actually, the court has used this power by ordering a ceasefire in the case of Russia-Ukraine. And it ordered a ceasefire, a unilateral ceasefire. It only ordered Russia to cease fire. The other arguments would say, no, but the court, kept consistency with its previous decisions. It's true that the court did not order a ceasefire in Bosnia, Serbia, in the Rohingyas case, and in the Gaza case, but it did order a ceasefire in the case of Russia, Ukraine. So the conclusion that I draw from that is that the court is not willing to order a ceasefire regarding genocides that are affecting Arabs, brown and black people, but yes, in the case of genocides targeting white Christian communities. So you see how the court actually somehow participated in this sort of exercise of administration of violence. And some people were telling me, well, but your argument is contradicted by the last decision of the ICJ regarding the occupation, because it's completely favorable to Palestine and dismisses all the arguments of Israel and other states. But and here I wanted to address this comment to Michael Link, if he has any thoughts about that, because this is a critique done by Badil in Palestine. Okay, the Palestinian organization Badil is saying, well, it seems that the decision from July 2024 is nothing but another exercise of administration of violence. Why are they saying that? Because despite its positive dimensions that we should highlight and use in advancing Palestinians' rights, no doubt about that, but there are flaws in the decision according to Badil. For example, they say the decision endorses, sorry, and I wanted to say, maybe, Michael, the decision of the court was limited by the questions that were asked to the court. And of course, there are some of these flaws that I will mention, that Badil is mentioning, come from the limits that the very question posed to the court can set, right, for the court. But nevertheless, the decision, says Badil, endorses a two-state solution rather than a right-based solution. The decision places Palestinians in the same level, at the same level than Israelis. The decision refers to foreign occupation rather than colonization, settlers and settlements rather than colonies and colonizers. The decision does not mention apartheid, but rather the violation of CER, the Convention Against Racial Discrimination. The decision disconnects apartheid from the Israeli colonial project. The decision does not make any link between the Israeli policies after 48 and after 67. There is no mention in the decision of the Nakba and colonization prior to 1967. There is no mention of the link between the right of return and self-determination. The decision excludes Gaza Strip and 70 years of siege and ongoing genocide. And finally, the decision completely ignores the right of return. Now, these are the critiques of Badil. Now, I would add one critique that Badil does not mention and is very important, which is the Badil's position does not mention that despite the court resorting and referring in the decision to use ad bellum, meaning the right to use military force, the court never qualifies the Israeli occupation as an act of aggression. And the implications of this are very important, right? And go in the same line. I think the court does not qualify the occupation as an act of aggression because doing so would mean force the court to correctly apply the rules of jus ad bellum and to consider actually the 7th of September, the 7th of October, right, as an exercise of the right as an exercise of self-defense, actually. So I want to finish by saying that this critique, is linked to another one, which is more global to the use of international law regarding the Palestinian question today, which is that how international law has been used or is being used as a disciplinary tool to dictate to Palestinians what they can want, what they are, and what they can desire even to be. In the sense that, the only international laws that Palestinians are allowed to resort to in order to qualify their condition is international humanitarian law. This is the law of the victim. But they are not allowed, for example, to resort to other corpuses of international law as the additional protocols to the Geneva Convention that, according to which the conflict between Palestinians and Israelis is an international armed conflict, right? And at the same time, the protocols recognize the right of resistance. This is why I think the ICJ does not qualify the occupation as an act of aggression, because otherwise it would have to explicitly apply the additional protocols and recognize the right of resistance, something that the court is not willing to do. Thank you for listening to me, and I would love to, to hear from all of you if you have anything, but particularly from Michael regarding the critiques of Badil and the critiques that I added myself. Thank you so much.
Thank you so much. Professor Link, would you like to give a quick response to that?
Sure. Let me be very brief, and let me thank Emilio for his presentation. I think he points out how far international law has yet to go with respect to making it an effective tool for the realization of human rights and self-determination for the Palestinians. I have a copy of the Badil critique. I haven't had a chance to read it yet, but I have a general idea of what their comments are. First, let me say this: I'm as someone who's worked for some time in international law, I don't think at the end of the day the problem is international law. I think international law contains the kinds of values that accord with justice, that could contain the kind of prohibitions with respect to discrimination, with respect to genocide, with respect to apartheid, that we all would wind up seeing. The problem is not fundamentally international law. The problem is international politics. International law doesn't have its own army. It doesn't have its own police. It's not self-executing. So when a proclamation is made, either through a UN resolution that amounts to international law, or an advisory opinion from the International Court of Justice, or a binding ruling from the International Court of Justice, or actions at the ICC, the issue always is, can it be married with international politics? And invariably, we have political barricades at the United Nations, particularly erected by the United States, that wind up protecting Israel. Notwithstanding that, let me say my overall opinion of the International Court of Justice's advisory opinion in July is that it's a great step forward. We have been dealing with respect to the occupation of Palestine since 1967, and obviously the consequences of 1948 and the Nakba. We've been dealing with this as a matter of realpolitik, particularly expressed by the 1993 Oslo process that has continued on for the past 30 years. In other words, might makes right. Israel is allowed to be able to maintain most of what it's been able to seize in terms of land and property, in terms of the establishment of settlements, in terms of the size and power of any punitive Palestinian state. What I think the ICJ's advisory opinion in July says is that it's now, we're looking at an entirely new paradigm, where before we looked at a lawful occupation which had illegal aspects to it, the annexation of East Jerusalem, the creation of the 200 plus Israeli settlements, and so on. Now we're dealing with a rights-based paradigm. We're shifting from one to the other. And even if it doesn't answer the questions of 1948, it does answer many of the questions with respect to 1967. I would mention, Emilio, your point with respect to settler colonialism. I've used the word, when I was special rapporteur, of settler colonialism as well. Settler colonialism is not yet a legal term, alas. And I think that is a job for lawyers like you and I, and Haroon and Lex, in the time to come, and other lawyers, to begin to put legal content into settler colonialism so that it becomes a part of the same type of vocabulary as genocide and apartheid. I do agree that there's a common cynical, and I understand where the cynicism comes from with respect to Palestinians and their view towards international law, and obviously the comments made by someone as prestigious as Raji Shourani in the last few weeks. Gaza has become the graveyard of international law. I understand where that sentiment comes from. I understand all the failings with respect to international law and the Palestinians. I accept that the Palestinians are both legal and political orphans of the international system. But I do think that international law, viewed at its highest, is an aspiration, and that it's worth defending by all of us, because it represents, I think, the very best of humanity. How it's put into action, I believe, is quite another question, and that goes to the realm of politics and international resolve. So that's my stance, and I'm familiar with other critiques by Badil with respect to this. I will try to read the Badil critique in detail in the next short while, when time allows. But my sense is to defend what international law has provided in terms of its framework. I defend what the International Court of Justice has done in both January and in July. And I think that our actions have to be on other spheres, in the active spheres of politics, in order to realize what international law can give us.
Thank you so much for that, Professor Link. We've been joined by Sarah Flounders. Hello and welcome. The co-director of the International Action Center.
Hello.
Hello.
Should I, do you have an opening question to me, or should I just jump in here?
Why don't you go ahead and speak? We do have a question that we would that was asked earlier of Professor Link, but that that is also relevant to your expertise. I can maybe I'll go ahead and ask that now. So earlier this week, UN Special Rapporteur Francesca Albanese stated that the UN should consider suspending Israel over genocide. And what steps would member countries need to take to pursue this suspension? And additionally, what do you believe that this could ever be realized, or will the U.S. continue to be a major barrier? If you want to add, if you could go ahead and
Okay.
add this on
Yeah,
to
well,
what you
I can comment on that. Let me first say, I am not a lawyer, and so I'm part of this discussion. I am deeply a supporter of the Palestinian struggle and of the right to resist, and does that today. There all kinds of double wording is used, but it's not much different from, we should remember, for hundreds of years, the enslavement of people was absolutely legal. And here in the US, there were courts and court rulings and decisions that you could argue 10 different ways, and yet slavery continued legally. That was the purpose of law, to guarantee property over people and over people's rights. So it is to cloak what's an administration of total violence in some supposedly God-given or people agreed to mandate. So on the other side, and I think this is important, what has been established in reality on the ground is the right of people to resist complete violence and subjugation, and to assert their right to govern, to control their own destiny. So the ICJ is trying to thread a fine needle, you could say, and to the lawyers who want to try, but they are not the ones who make history. The ones that make history really are the forces on the ground who have refused to accept a completely unjust situation, not necessarily an illegal situation. And that is the quandary, the dialectic of this. It's US policy to support absolutely, completely, this colonial project that they created as the enforcers in West Asia of their rule, of their domination. From the very beginning, that was the purpose of the establishment of the State of Israel and of the whole Zionist project. So now at the UN today, the idea of suspending Israel, I'm sure if it was put to a vote, the overwhelming majority would say this illegal genocidal state has no right to be represented here. That's a given. Would the US go along with this? Absolutely not. And I think we know that. And we know that law to them is really irrelevant. In the international situation, it's power, might makes right. Before such a vote, I'm sure they would probably double the amount of weapons that they're sending as their way of arrogantly refusing to abide by the very international law that they so carefully constructed. And that is what is going on today. They created a whole body of law, and they have created quite a web in order to continue their rule. And now it's being shredded. It's being broken apart by the people themselves and all the people of the region. So, as I say, I'm not saying this as a lawyer, and I'll have to leave that to the lawyers to argue. But I think in the world today, we're seeing a new reality. If this was left to the lawyers, we could just look at what happened at the UN meetings where Netanyahu came and spoke to the entire General Assembly. Now, there was a walkout. That's a nice, polite thing to do. But the very idea that he would come, be hosted with all kinds of parties, let alone the address itself, is a flaunting of any kind of ruling and international law, and is beyond an insult. It was the U.S. asserting this is their proxy in the region, and no crime that is committed will they do anything to really oppose. Once in a while, they'll wag their finger, but they will not do anything that really challenges their proxy, who is being defeated, who's utterly failed in this war, failed to defeat the Palestinian resistance and failed to defeat resistance in Yemen, in Lebanon, Iraq, the whole region. So this is where law and reality do reach a real contradiction. There was great excitement just a few months back that an ICJ ruling would carry weight, would be able to stop the war. There were a lot of excitement that, an ICJ ruling, and instead it was sort of lost in words, and the struggle moved on. Those who had looked to the court to be able to do something, it's true, it has no enforcement. Even if it made a great ruling, even if it made the strongest ruling in the world, it would be flipped aside by U.S. power, U.S. imperialism that is determined to dominate the world and is losing its hold. And so they want to make an example that for those who defy their rule, there's no limit to the violence that they will commit. And so I think globally, the support for Palestinian rights, for the Palestinian resistance, has only grown in admiration given what they're up against. But I'm saying I can't speak as a lawyer. I can't refer to any of these documents because I would be immediately at a loss. But I do think, particularly, I thought Emilio's points were very effective to me. That was where I tuned in. So thank you.
Thank you so much. Thank you so much, Ms. Founders. I wanted to, that your insight is very much appreciated. I would like to direct you back to Harun Raza, who would like to, who has a comment to make before we give closing statements. Thank you.
Thanks very much indeed. I have two very short points. Thanks very much to Sarah for valuable words. Legally, if we look at the situation, let's say from 2016 up to 2023, very shortly, regarding resistance, we all know that in 2018, there was a March of Return in Gaza, which was civil disobedience, which was peaceful protest. That didn't get the Palestinians anywhere. In fact, they were killed at rates which hadn't been seen before. So if we look at the way in which, if we look at proportionality and the issue of proportionality according to international law, and we look at the 7th of October, then it seems to me, not as a specialist lawyer, but as a lawyer with some experience and not as specialized as the other esteemed members of this panel, that in layman's terms, if you've tried it peacefully and there isn't any way to solve your situation, which wasn't there for the people living under the illegal blockade of Gaza, then you have to step up your game. And I believe that's what happened on the 7th of October. Having said that, I actually wanted to say something about what Emilio was talking about regarding settler colonialism. We have on the 30th of December 2023, so 11 months ago now, we have lodged a complaint against a binational settler with Dutch and Israeli nationality at the public prosecutor's office here in the Netherlands regarding his participation in being an accessory to war crimes and or crimes against humanity and or other crimes. And we've, on behalf of March 30th Movement and the Hind Rajah Foundation, and we've worded that complaint very broadly. So we've given the prosecutor's office room and space to conduct their own investigation, specifically into settler colonialism and the crime of settler colonialism, because I don't think there's any doubt whatsoever that it is a crime. And in fact, it's a crime also along Dutch lines, because that individual who the complaint was directed against has Dutch nationality. And according to Dutch law, there's universal jurisdiction. So we are very hopeful that something will come out of that complaint, hopefully, and it will lead to at least some type of investigation, and you never know, an actual prosecution. Just to add to the two previous speakers. Thanks very much.
Excuse me, I just want to interject something here, if I may, that it is illegal according to international law to kill civilians, no matter what. October 7th was a war crime. And that's why you had 3 leading Hamas leaders indicted, or proposed or recommended for indictment by this same committee that recommended the indictment of 2 Israeli leaders. And to say that there was one attempt, this one attempt to nonviolent action failed, so therefore it doesn't work. I mean, there have been that's like saying one gun battle, firefight in which the resistance was defeated means violence doesn't work. That doesn't make it. It's not that nonviolence works or violence works. Do you have a strategy to win? And we have seen countries under occupation that have freed themselves through nonviolent resistance: Latvia, Lithuania, Estonia, even India, and others. And the bulk of the resistance in Palestine has been nonviolent and is ongoing, particularly in the West Bank. So I really have problems with this very simplistic either-or kind of definition. And yes, people under occupation have the right to resist, including armed resistance, but it cannot be against unarmed civilians. That's very clear in international law.
I agree with that last point, and that wasn't my point. My point was very simply that if you are under occupation, in fact, continued occupation since 1948, and you have been trying peacefully to gain your rights, and you have been oppressed in the way in which the Palestinians have been oppressed, there will be some blowback from that. That was my simple point. And I'd also like to say 2018, or the March of Return, wasn't the first and was not the last non-violent action by Palestinians. Just to reiterate that point. Thanks very much.
Okay, thank you for that, and for sharing those remarks. I think this webinar could probably go on for another hour or so.
I'll make just a closing.
I'm going to have everybody, before we wrap up, I'd like to hear a call for action and any closing comments that you would like to make. So we'll just kind of start at the top and continue down. So if you could just share your thoughts on any crucial steps that you would like to recommend, along with any closing statements, and in addressing the challenges that we've discussed. Let's start with Professor Ling, please. Thank you.
Thank you for that. And listen, thank you again. This has been an incredibly stimulating discussion over the last hour plus. And there's much that I've learned from all of the other speakers. In a minute, the hole in the heart of the question of Palestine with respect to international law is the issue of accountability, is the absolute lack of the ability of the United Nations to enforce its own resolutions. International law has a number of tools, including the Common Article number 1 of the four Geneva Conventions, the Articles of State Responsibility, particularly Articles 40 and 41, which demand international cooperation to bring to an end a serious breach of international law, and Articles 6 and 25 that I've discussed already with respect to the Charter of the United Nations to deal with errant and outlier members who hold the United Nations in contempt. At the end of the day, we'd have to look at the principles of BDS, of boycott, divestment, and sanctions. The three principles are all well embedded in international law. Number one, end the occupation. and allow the realization of Palestinian self-determination. Number two, equality for Palestinian citizens of Israel, full quality in a state of all its citizens. And number three, the right of return for Palestinian refugees, which has been in international law now for almost 80 years. All of those are, if we can find the path to their realization, will go a long ways to finally justly settling and finding a durable solution for the question of Palestine. Thanks very much.
Thank you so much, Professor Link. Let's continue. Harun Raza, how would you like to, could you please make your statements? Thank you.
Yeah, thanks very much for your time and for the opportunity to speak here. I agree with Stephen, just to get back to his point. Of course, we're against all killing, and that's why we are here on this webinar, to make sure all civilians, of course, including Palestinian civilians and other civilians, are protected according to international law. And I think that the past 75 years, and especially the past year, has shown us that there is a type of double standard regarding the way in which the international community weighs lives. Brown lives and non-white lives seem to matter less, I'm ashamed to say, than white lives and other lives. And I think it's our duty as lawyers and professors and other activists to make sure that this disparity, this injustice is set right. Thanks very much indeed.
Thank you. Dr. Lex Steckenberg, how would you like to, if you would like to make your closing statements, please, and call to action?
You're muted, Lex.
Thank you very much again for the very enriching and insightful webinar, and I echo Michael Link's words that I learned quite a bit from the various interventions. I believe we are at a pivotal time, both with respect to the sort of the implementation of international law as it concerns the question of Palestine, as well as more generally the whole discourse around the question of Palestine. One important way Israel has succeeded to shield itself from accountability and to maintain the very widespread Western support for its actions is by weaponizing anti-Semitism and by successfully mobilizing that against any politician in the West who may dare to sort of criticize Israeli actions. I think we're reaching a point that individual politicians, perhaps not so much yet in the US, but definitely in Europe, really have to sort of choose between do I want to or do I concern more about being branded as an anti-Semite, or how does it appear on my CV? Many of those politicians are still young. If I was on the wrong side of history, if I will be seen and documented as having enabled a genocide and mass atrocities, as we are witnessing them day after day. And I think this, they're individuals. They have political aspirations. They have many of them have careers ahead of us. I believe that this is increasingly going to determine and to further sort of turn the tide. So I think we really are at a critical time, and I believe we should simply continue with what we have been doing, is trying to use the law to the best of our ability to defend Palestinian rights, to further engage the solidarity movement, and use the institutions that are there to indeed, as many of you have suggested, sort of to decolonize them, so that we can eventually sort of successfully achieve the decolonization and liberation of Palestine. So we should not give up and keep working day after day for this goal.
Thank you so much, Dr. Zuckerberg. I would like to turn again to Professor Zunes for your closing statements and call to action.
Yes, I mean, international law, as imperfect as it is, can be a very powerful vehicle. I mean, the United States, I know very well how the laws are used to perpetuate racial and economic injustice and the like, but nevertheless, the law can be an important tool for defending civil liberties and upholding basic rights. And so, similarly, I think with international law, we should not be naive about, the lack of real enforcement mechanisms and the like. It can be a very powerful tool, particularly in the West, of raising awareness that this is not simply about opposing Zionism or ideological issues. This is just basically saying that Israel, like any other state, has to abide by certain international legal standards. I mean, that's something that we can get a wide variety of support on, just because, this is so much about what how Western nations see themselves. That and with Russian the Russian invasion of Ukraine, we have President Biden saying no country can unilaterally expand its international borders. No country can expand its boundaries by force. We have to uphold a rules-based international legal order. And if they are going to keep arguing that, we can say, hey, if you really believe this, then you need to pay attention to Israel and Palestine. You have to stop aiding and abetting these violations of the international legal norms that you claim that we are supporting. So I really do think that whatever its limitations and lack of enforceability, that international humanitarian law and international law in general can be used to raise awareness, to challenge U.S. and Western policy, to make it more and more difficult for the West to aid and abet these ongoing crimes, by Israel.
Thank you, Professor Zunes. Dr. Emilio David, can you give your closing statements and call to action?
Yes. Thank you so much. I wanted to make some general comments. Michael, colonialism is a legal concept, right? I mean, the additional protocol mentions it and makes it a legal concept. Now, I agree with you that we should work on flesh it out more densely and in legal terms, but it's not a concept that is alien to international law at all, right? The second thing that I wanted to say is to Stephen. I don't know if I misunderstood you, but your words suggested to me that that you said, well, in whatever the situation is, we should not kill civilians. Of course, right? But I don't know if you were making a judgment of the 7th of October itself, because if we are trying to decolonize law, like Lex said, well, we could start, for example, in here, right? I mean, in international law, there are, in the law of war, there are two sets of legal corpuses, right? One is jus ad bellum, meaning the right to exercise, to use military force, and jus in bello, right? Which regulates what can you do in war, right? So from a point of view of jus ad bellum, the 7th of October, from a legal point of view, is technically an act of self-defense. Now, if the 7th of October, if during the exercise of this right of self-defense, some atrocities were committed, which I don't have any problem to admit, and I think Palestinians in general do not have, well, that they are prosecuted, that they are brought to courts, right? And actually, liberation movements have a great history in trying their own people for war crime. The FLN did it in Algeria, the PLO did it during the civil war in Lebanon, etc. Right? So, but I think it's important to make the difference, the distinction. And finally, I wanted to say to Michael, with all due respect, Michael, I admire your work profoundly. So, but I have to disagree, because the problem for me, and as I see it, is not only a problem of enforcement of decisions, because the critiques that I was addressing are critiques to the decisions themselves, to the assumptions, right, that the courts are adopting. For example, not qualifying the occupation itself as an act of aggression. Why? Right? Or why did you not order a ceasefire on the 26th of January 2024? You didn't have the court did not have any legal or factual argument not to order a ceasefire like it did in the Russian-Ukraine case. So you see, the problem is not just a problem of implementation or enforcement of decisions, but sometimes the problem are the decisions themselves or part of the decisions. And finally, my call to action, and here you will see the academic side of my work. I would say, for me, one of the most important actions today is, I'm not calling for a cynical position regarding international law. It's not cynicism, but it's not about being cynical, but about being critical. We can use the positive dimensions of all these decisions to advance Palestinian rights, and at the same time we can make a solid critique of the courts and hold them accountable for their decisions. You see, thank you so much.
Just to answer your question, yes, if the October 7th attacks had gone exclusively against the military installations, there were attacks on military installations. That would certainly be legal. So again, I would agree there. Now, one can debate whether armed resistance, given the nature of the conflict, is the smartest strategic move or not. But again, the legal right to armed resistance, as long as it avoids civilians, is there's no question there. But I want to just mention that this is not the reason, of course, for the U.S. position supporting Israel. Let's take Western Sahara, the other big military occupation. The Polisario has never questioned Morocco's right to exist, never engaged in terrorism. They're actually relatively democratic, and yet the United States actually formally recognizes Morocco's illegal annexation of the entire nation of Western Sahara in defiance of the General Assembly, the Security Council, the International Court of Justice, etc. So let's not let's not pretend that the U.S. Continues to support Israel because of terrorism or non-recognition or lack of democracy or anything like that. The U.S. is willing to support allies engaging in war crimes and illegal occupations, regardless of the tactics of the opposition.
Okay, this has been quite informative and quite lively. I would like to move on. We have one more speaker to hear from, closing statements. Sarah Flounders, would you like to give a closing statement and call to action? Thank you.
Thank you. Yes. And I'm very glad that the March of Return was raised, because this was one way in which the whole population of Gaza learned through their direct experience the complete disregard for their rights, even in totally nonviolent actions. And it did, in a very concrete way, lead to October 7th as the only alternative. They were facing complete expropriation and removal. And that was made clear by Netanyahu at the UN, that total expropriation of the Palestinians from Gaza was the Zionist plan. So they learned through experience the limitations of nonviolence, even with mass participation. I think on a global scale, what has happened is Israel is now stripped not just of operating with any legality, but with any legitimacy. And in the long run, this is really the end of Zionism as even among its own population, which is shattered and breaking in 10 different ways, and its ports are closing and its economy is shutting down. And many of its soldiers are refusing to fight, and lots of people are leaving the country. So there is they are seen internationally as an apartheid state. I also do think that this resistance has shown that the US has no respect for law, for human rights, for legality. They side with genocide, and they are the real aggressors, the suppliers of the weapons. That is clear to the world. And there was great confusion on this before, that somehow the US could be relied on as an impartial negotiator. That no longer exists. And as a matter of fact, in Europe, and increasingly globally, even the term for the G7 is being called the Genocide Seven, for their siding with Israel. That's important. There are changes happening in world consciousness that we want to see, understand, and recognize that is the real change, that some of the structures that they've so carefully crafted, when they disregard them and blow right past them, people take note. There is a complete disregard for civilians and a double standard that we also see, and I just want to make mention of it here, the sanctions imposed on Gaza since there were, in 2006, completely legitimate UN-supervised elections that Gaza won, that Hamas won in Gaza. US and Israel didn't agree with those elections and enforced starvation sanctions on Gaza. That was really done by the US on an international level. The sanctions against Gaza, completely illegal by every standard of international law. But again, this is the United States government has been utilizing sanctions now against more than 40 countries, a third of the world population. And the sanctions are war on civilians, deliberate, calculated war on civilians to create famine, to create disease, to deprive populations of food, of medicine, of basic supplies, of electricity, water purification. That's the whole purpose of sanctions. They're being intensified, and it is leading to a world resistance against the use of this weapon directly targeting civilians. So my call to action is that we absolutely continue to support Palestine. We also draw the links to the other countries that the US is sanctioning, is trying to starve down within the region. That includes Yemen and Lebanon and Syria and Iraq and Iran. I could go on, but really the countries of West Asia are sanctioned by the US in an effort to shut down, to recolonize. And I would call for recognition of this criminal role of sanctions as a war on civilians. The continuing, the support for Palestine, I do urge the lawyers here to use their skills to defend the rights of so many of those who have been in the streets in defense of Palestine here in the US, and this is true throughout Europe, have been mass arrested, have had scholarships canceled, have had all social media shut down, completely illegal. And every kind of excuse is used. Every one of these students and groups and mass demonstrations need legal support, and we rely on it. So I do think there's a real role for lawyers to play. We can look at even Sami Doon as an organization defending Palestinian prisoners. legally in every way stripped, branded, its social media access shut down, and so on. So I think there's an important role for lawyers to play in defending the rights of those who are standing with Palestine in this very difficult time. And I really do feel that that Israel and Zionism have suffered a setback that they will not recover from, and so has U.S. standing in the world, and that's an important accomplishment. But we got to do more in stepping up our support and solidarity. So thank you for this. And I'll also apologize due to time zone changes. I think you didn't realize, or I didn't realize, that daylight savings time screws up lots of clocks here. So thank you.
Thank you so much for that. Yeah, Sarah, I'm also in the US, and I woke up this morning to the same issue. So yeah, there's time change is very difficult. So I'm very, very glad that you were able to make it and to hear your words. So thank you, everyone, for your insights and expertise. Once again, this has been a great honor to moderate the webinar, and it's been deeply informative. And I look forward to continuing to hear from all of you, and hopefully soon it will be in better times. Thank you.
Thank you.